Then just a 10-minute drive down the highway, this is the scene, neighboring Pullman, Washington. That's Brian Kohberger's home at the Steptoe Village Apartments. It's also been a beehive of activity where Kohberger was living on the night of the murders. And of course, the investigators have done a full search inside that apartment. They've hauled out loads and loads of evidence, including a computer tower. But all we know is what we saw with our own eyes, because as I mentioned earlier, the search warrant is sealed. Both the reason for them going in the first place, and then the accounting list of everything they took out. Saw the reason for the affidavit being sealed. I just thought it was pretty strident. I mean, some of the language made me think, heavens to Betsy. I mean, I've seen search warrants sealed before, and it says we want to preserve the investigation, period, end of story. But they used this language that was, prematurely end the investigation, threat to public safety, the personal privacy interests of the witnesses, the victims, and the victims' families.
And I will tell you, there are some rumblings around. I don't know if you saw the other day, there was a search warrant that was sealed. One of the reasons they gave for the sealing was very curious. There are all kinds of things that are swirling around this, and as any competent, he clearly has a very competent defense lawyer, would take the time to do the parallel investigation they need to do.
What was this squirrely language around the warrant, Mark?
There was some language in the warrant that, if unsealed, not only would it compromise the investigation, but that arguably it would threaten law enforcement. That tells me that there's something there that they don't want out yet, or something that they missed, and they're afraid that if it got out, that there would be public, what I call blowback. And I think that that's a legitimate concern. I will tell you, I've seen I can't tell you how many thousands of warrants that have been sealed. Rarely have I seen one where the reason centered on the threat to law enforcement.
Coffindaffer, are you similarly concerned?
Yes, definitely saw that as sort of a very unusual language to use, and particularly since we have the complaint affidavit unsealed, why aren't they unsealing those search warrant affidavits? It's not making a lot of sense, and I agree with Counselor Garagos on this one.
Yeah, I'll tell you, there's a suspicion that when they said, we talked about when the police came out and they said, this is the guy, we're 100% certain, there's nobody else that's going to be arrested. I think a lot of that is being called into question now.
Okay, so a few things you need to know about this document. This is the motion to seal both the probable cause for the search warrant and the contents of the search of Brian Kohberger's Pullman apartment on the WSU campus. So this was filed on the same day of his arrest on December 30th of 2022. If I'm remembering correctly, I believe he was arrested at around 2 a.m. at his parents' house in Pennsylvania on the 30th. So this would have been filed on that same day. And basically, this document was not written by an investigator. It wasn't written by the prosecutor. This document is written and signed by a Superior Court judge for Whitman County in Washington. So to keep this information under temporary seal and out of the public's hands, they have to give compelling reasons to do so. And that's what this document the motion to seal does. However, the language is really weird, as some experts have concluded. So we're going to go through this and discuss what this could possibly mean. The motion reads, "This court, having previously considered the application for search warrant filed in this cause and the declaration of Don Daniels, Assistant Chief of Police, WSU Police Department, in support of the state of Washington's motion to seal file in this matter, and being fully advised in the premises, hereby makes and enters these findings of fact. 1. Impact on effective law enforcement and public safety." See, this is what really gets me. This is really, really weird to me. If the only suspect, as Moscow police says, is in custody and they don't expect any more arrests, how does any of this make sense? So let me read this part. "This matter is in the investigative stage, and while criminal charges have been brought, those charges are not yet publicly known." Pause. So this, like I mentioned, this was filed on the 30th. So when this document was being drafted, it's possible the public had not known about the 4 first-degree murder charges and the felony burglary charge. And I think that, all charges at this point that have been brought for Kohberger, I believe, we're aware of. So it does make me question whether there are more charges for more individuals as of the 30th. "Premature public disclosure of the details of this law enforcement investigation will create a serious imminent threat to effective law enforcement and could result in the premature end of this investigation, which could create a threat to public safety." So this is so weird because we have the probable cause affidavit and that thing was juicy. And I think after reading that, a lot of people who may have been doubtful about law enforcement's capabilities ate their words. So that affidavit made law enforcement look pretty good. And it gave us a lot of information, a heck of a lot more information than is typically in a probable cause affidavit. So that makes me question why the search warrant is sealed. So the second reason, and this one's totally understandable, 2, personal privacy. The personal privacy interests of the witnesses, victims, and victim families named in the application filed in this cause also supports sealing the documents filed in this matter. Interesting. So I think most of us can understand that it makes sense to protect the privacy of those involved in the investigation. To me, this kind of reads as just a pile on reason for that first reason, because all this information is going to come out within 2 months. So all this information is going to come out by March 1st. So maybe that could be like a courtesy for grieving family members, give them a little more time to kind of process rather than making all of this public all at once. Because it's got to be pretty overwhelming with the gruesome details, especially released in the PCA. But I think the information in the search warrant, both the PCA and the contents of the warrant, will speak to the connection that we have not yet been able to nail down. So that's kind of what I think this second point is about. I think that there could be sensitive images of the victims. This could reveal that connection that I know that Steve Gonsalves did cite a connection that they're aware of with Kaylee, but they weren't ready to share that with the public. And then their attorney did come out and say, to kind of clear the air, saying there is no connection. So that's still to be known, but I have a feeling that the search warrant contents and the application for the warrant may contain information as to that connection. The witnesses, that's an interesting thing. And I still have questions about the witnesses, but it's interesting that they're included in this personal privacy point. 3, limited sealing. For these reasons, the information contained in the application and the nature of this investigation must be kept secret for a limited period of time. It is estimated the investigation will likely be concluded within 2 months from this date. So an order sealing the file for that period of time is appropriate and necessary. Again, these are the words of a judge, not an investigator, not a prosecutor. This is the judge saying this. So the prosecuting attorney may seek an order unsealing the records if the Idaho investigation and/or criminal case proceeds more quickly than currently anticipated. For the immediate future, no action short of total sealing of the records in this file will protect the above interests. intense. So based on the foregoing, the court now makes and enters the following conclusions of law. 1, jurisdiction. This court has jurisdiction over the subject matter herein because the search warrant was served in Pullman, Washington. 2, effective law enforcement and public safety. There exists a serious and imminent threat to efficient and effective law enforcement, to public safety, and to the public interest in law enforcement's ability to completely investigate criminal activity using all tools lawfully at their disposal to collect evidence of criminal activity, and no means less restrictive than sealing the listed documents herein will protect those interests. 3, personal privacy. There exists a serious and imminent threat to the privacy of the witnesses, victims, and victim families named in the affidavit, and no means less restrictive than sealing the listed documents will protect that interest for the time being. 4, limited sealing. The above interests do not require protection for an extended period of time and can be served by sealing these documents until March 1st, 2023, or until need for sealing changes, whichever occurs first. So it could be that we get this information before March 1st, but they do concede here that these interests don't require protection for an extended period of time. 5, compelling circumstances. Weighed against the public interest in the open administration of justice, compelling circumstances warrant the temporary sealing ordered in this matter, signed this 30th day of December 2022, and signed by the Superior Court judge.
The sealing order had language that I have frankly never seen, or I can't remember ever having seen, which was part of it was they did not want law enforcement to be exposed to threats or intimidation and expose the investigation. Now, exposing the investigation, I've come across a zillion times. That's standard operating procedure. Threats to law enforcement leads me to believe that there is something that apparently they missed, or a thread that they missed, or didn't, or got out in front of their skis. Remember, the officers had said, we're 100% certain this is the guy, nobody else. I think there is a suspicion that there is somebody else or someone else in the mix.
Whoa.
And I think that sealing would be an appropriate way of tamping it down. You just don't want to let out information that could be the way you catch a liar or the way you spot the truth. Those details are the way you test what witnesses say. And if you let those details out, you run a very real risk of skewing the investigation.
But Mark, don't you think, that the warrant in support of affidavit in support of the arrest warrant is 18 pages long. We have so many details from that. Why allow that one out into the public domain, but not this one?
Well, I don't disagree with you at all. I was speculating, and that's all we do here, I guess, but I was speculating that the defense might have requested that remain sealed, but the cynic in me thinks that because the officers in the police department had taken so much heat, as Marcia describes it, that they wanted to show, and I believe it was the chief, had indicated that once it was unsealed, they would be vindicated, so to speak. And I suppose that's one explanation. I still think there's something else going on here. I suspect that there is another source profile of DNA or something else that was found at the scene. I just don't think, when you take a look at the timeline of this, and you know that there is a DoorDash driver there at 4 a.m., and you know that there is a spotting by DM, as they call the person in the affidavit, of somebody in the hallway. There's just, I believe that there is more here than meets the eye, and we're just not going to see it. And I think it's one of the reasons that the defense so readily said they would waive time until June on their speedy trial rights of the preliminary hearing.
But they used this language that was, prematurely end the investigation, threat to public safety. Darren, I'm going to start with you. As the lawyer, what do you make of that language?
Well, I think the threat to public safety is the idea that if they release the affidavit and the items that were actually seized, that it could compromise the investigation, and that the individual that everybody is so confident actually committed the crime may be able to dodge a bullet as a result. That the integrity of the investigation would somehow be threatened. Although I hate to take the wind out of anybody's sails, but I'll just remind folks that are feeling this sense of relief as they go back to school that an arrest is not the same as a conviction. And there's a very different standard of proof that's involved. And of course, that's one of the fundamental reasons why that the information concerning the search warrant is kept under wraps.
I'm going to quote, "The personal privacy interests of the witnesses, victims, and victims' families named in the application also support sealing the documents filed in this matter." Look, I always feel for victims, Darren, but the personal privacy of the witnesses, victims, and victims' families, I'm trying to figure out what that means. What was in that apartment that might affect the witnesses and the victims' families? I mean, I've got visions of like flow charts of who's going to get murdered next and when they shower and when, you know what I mean? Like that's what my mind goes to. Is that too much?
Well, no, it's not too much. I mean, that's the kind of obviously very compelling evidence that law enforcement officers hope to discover in this guy's apartment would be evidence that he planned or participated in other crimes. But in terms of the language that you're pointing to, you know, I think about the victims here. And oftentimes victims make certain lifestyle choices that could subject them to public criticism. There could be private medical information that you just generally out of decorum don't want that information released to the public.
Is our community safe, or is law enforcement still on the search for other suspects who might be involved in this attack?
What I can tell you is we have an individual in custody who committed these horrible crimes, and I do believe our community is safe, but we still need to be vigilant, right? We still have talked about this in the past. We always need to be aware of our surroundings and make sure that we're aware of what's going on.
So, Jimmy, you know, they're not ruling it out. The suspect allegedly said when he was getting arrested that there may be, that you catch someone else as well. What do you make of this news?
Well, I certainly wouldn't feel any safer if I was in that community based on the answer he just gave, because it did sound a little bit evasive.
And they said, this is the guy, we're 100% certain, there's nobody else that's going to be arrested. I think a lot of that is being called into question now.
Meaning what? There's somebody else, or that it's not
Meaning
him?
potentially that they think there's some other complicity here. There's some other liability here. There's something else going on here that made them necessitate closing or sealing that warrant to the public until March.